Welcome to Diagnosing Health Care, a podcast featuring thought-provoking conversations about the latest legal, policy, and regulatory issues in healthcare and life sciences. Brought to you by the lawyers at Epstein Becker Green.
Hello and welcome. I'm your host, Rachel Snyder Good. I'm Strategic Counsel in Epstein Becker Green's Healthcare and Life Sciences practice based out of our Baltimore and Washington, D.C. offices. We are recording in our Washington, D.C. office today, just down the street from the White House and a few days away from the one-year anniversary of President Biden's landmark executive order entitled Safe, Secure, and Trustworthy Development and Use of Artificial Intelligence. This executive order laid the groundwork both for how federal agencies should be responsibly incorporating AI within their own workflow, as well as how each agency should be regulating the use of AI in the industries they regulate. The executive order was not specific to healthcare, but did, for the first time, provide high-level guidance on the future of federal regulation of AI in healthcare. Today, we will take a moment to reflect on what is new in healthcare AI as a result of the October 30th, 2023 signing of the executive order, and discuss what healthcare industry stakeholders should be doing to comply and prepare for future federal regulation of AI in healthcare. If you like what you hear today, please like and subscribe to the show. Diagnosing Healthcare is available wherever you get your podcasts. Joining our discussion today is Lynn Shapiro Snyder, senior member of the firm who just celebrated her 45th anniversary at Epstein Becker Green, based in our Washington, D.C. office. Lynn, thank you for joining for this conversation.
Thank you for including me.
Also joining us today is Eleanor Chung, a healthcare litigation attorney with a deep breadth of knowledge on AI regulation out of our Washington, D.C. office. Thank you for being with us today, Eleanor.
It's great to be here and to take some time to think about the accomplishments in the last year in this space.
To set the stage for our listeners, executive orders are important tools a president can use to set an agenda for administrative action only. These are not laws that have been passed by Congress, but instead a directive from the president to federal agencies to use their existing statutory authority to take regulatory action. Today, we will focus on three of the deliverables from the executive order that impact AI in healthcare. The first, the Health Data Technology and Interoperability Rule, also known as HTI-1. Second, the HHS, Office of Civil Rights, final rule on Section 1557, non-discrimination regulations under the ACA. And third, the requirement for each agency to designate a chief AI officer. The first deliverable, the HTI-1 final rule, complements existing and emerging policies across HHS and the federal government. HTI-1 supports the, quote, availability of documentation to help users determine appropriate and safe uses of AI in local settings in the health and human services sector, end quote, which is the direct language from President Joe Biden in his executive order. The Office of the National Coordinator issued this final regulation as one of the first actions taken a month and a half after the October 30th signing by President Biden of the executive order. HTI-1 was released on December 13th, 2023. The next day, on December 14th, 2023, HHS and the White House also announced voluntary commitments from key provider and payer stakeholders who these rules don't apply to in order to align with the executive order and HTI-1 for the safe, secure, and trustworthy use and purchase of AI in healthcare. After a reorganization at HHS in July, the Office of the National Coordinator for Health Information Technology, ONC, is now part of the Assistant Secretary for Technology and Policy. We will refer to this as ASTP-ONC. HTI-1 established the first of its kind transparency requirements for AI and other predictive algorithms that are supplied by certified health IT developers. Lynn, how does the HTI-1 rule that came out last year advance the cause for trustworthy AI in healthcare?
Thank you, Rachel, for this good question. The HTI-1 rule that came out last year advances the cause for trustworthy AI in healthcare by taking the first regulatory step. And what is the first regulatory step? Transparency. These are first of its kind federal regulations for improved algorithm transparency for artificial intelligence and machine learning-based predictive software in healthcare. This rule requires software developers of certified health IT to provide their customers with transparent information about what the final rule calls a predictive decision support intervention, or a DSI, that the software developer includes as part of the software developer's certified health IT module. So the users of the certified health IT must be able to access, complete, and up-to-date technical performance information from these software developers, referred to as source attributes, for these predictive DSIs that are made available to them by their software developers. I like to call it the bibliography of the DSIs. In other words, the first regulatory step is transparency around how the algorithms work, and more importantly, where the data comes from, so that the end users can decide for themselves whether they consider these AI tools to be trustworthy. The rule also requires the software developers of certified health IT to apply risk management and governance practices to their predictive DSIs supplied in their health IT modules. The goal is to monitor and manage the risk throughout the entire life cycle of the AI systems, so that the rule specifies that the risk management practices by the software developers must cover topics like validity, reliability, robustness, fairness, intelligibility, safety, security, and of course, privacy. As you can see from these terms, the rule draws closely from the NIST Artificial Intelligence Risk Management Framework. For those listeners not familiar with NIST, N-I-S-T, the National Institute of Standards and Technology, this is a section of Department of Commerce that has been working in this area for some time. The rule requires that a summary of these risk management practices be made publicly available on the ASTP-ONC's Certified Health IT Product List website. For those of you who may not be familiar with the jurisdiction of ASTP-ONC, this rule applies to health information technology, including electronic health records and certified electronic health records, that are used by more than 96% of hospitals and 78% of office-based clinicians nationwide. And the executive order was the catalyst to get these first-of-a-kind transparency regulations released by the federal government. Just to be clear, this is just transparency so that the buyer can understand how the tool they are buying or using works. It's similar to the transparency we all see on food labelings, or maybe when you buy a used car. It's providing the end user with more information. Whether the end user tests for trustworthiness, the rule talks about a primary goal of the HTI final rule is also to address what might constitute trustworthiness by promoting a phrase they're calling FAVES, fair, appropriate, valid, effective, and safe, FAVES. I also want to highlight that these new requirements become effective January 1, 2025 for the software developers of certified health IT that are supplying these predictive DSIs as part of their certified health IT modules.
Thank you, Lynn. These transparency efforts have been an important step forward. I know we have colleagues at EBG who have done some deep dive analysis into both the HTI-1 final rule and the HTI-2 proposed rule issued this past summer to advance interoperability and improve information sharing. We will link to those articles in our show notes for those that would like to learn more. That was deliverable number 1. For deliverable number 2, we turn to the HHS Office of Civil Rights 1557 final rule effective July 5th, 2024, clarifying non-discrimination requirements in health programs and activities as they apply to the use of AI, clinical algorithms, predictive analytics, and other tools. Eleanor, Can you explain further what this rule means for AI regulation and how it is impacting providers and covered entities?
Sure, and thanks, Rachel. I was just on a panel with Melanie Fontes Rainier, the acting director of the Office for Civil Rights at HHS, and her take on this new rule is that it is not very new at all. Discrimination is still illegal. The rule is a bit redundant in that way. However, there are a few interesting things about this rule. First of all, it applies to more than just AI tools. There is an AI provision in the rule because AI is on a lot of minds and there are question marks around it. The preamble gives us examples of non-AI applications, including the race-adjusted EGFR equation. So this equation is used to gauge kidney function in patients. From the mid-1990s through 2021, EGFR required providers to indicate whether a patient was Black or white. Based on that, an equation would spit out a measure estimating an individual's kidney function. Pulse oximeters can also have a race-adjusted option because some return elevated blood oxygen levels for patients with darker skin, indicating a better blood oxygen saturation than a patient actually has. The new rule doesn't mean that practitioners can't use race-adjusted EGFR or pulse oximeters. It means only that practitioners must identify the risk for discrimination in their use and to implement ways to mitigate potential harm stemming from these tools. So getting into the language of the rule, it prohibits discrimination, quote unquote, through the use of patient care decision support tools and states that covered entities have, quote, an ongoing duty to make reasonable efforts to identify uses and that entities must make reasonable efforts to mitigate risk. Patient care decision-making tools include things like the EGFR and pulse oximeter, tools that screen, diagnose, provide disease management guidance, etc. The rule does not apply to administrative and billing tools or anything used in revenue cycle management. Keep in mind that this is for the time being. A lot of folks in the industry expect to see the rule expanded to include revenue cycle management. I want to briefly return to the ongoing duty to identify and mitigate risk. The rule states that if a covered entity does not know whether a developer's patient care decision support tools discriminate, the entity should request the information from the developer. This means that providers and entities can't defer responsibility to the developer, particularly in light of ASTP ONC disclosure requirements. You must clarify with the developer that the tool does not discriminate. OCR will assess compliance based on an entity's size and resources, whether the tool is used off-label, whether the covered entity received information from the developer about the potential for discrimination. So in other words, whether the entity had knowledge of the discrimination and whether the covered entity has a methodology or process for evaluating the tool, which in other words means whether the entity has an AI compliance program. OCR endorses compliance programs. It has stated that, quote, covered entities may choose to mitigate discrimination by establishing written policies and procedures governing how clinical algorithms will be used in decision-making, including adopting governance measures. We have already helped many clients set up compliance programs, helping them to develop monitoring, training, and other governance measures.
Thank you, Eleanor. For those interested in more information on this rule, Lynn and Brad Thompson, the leader of our EBG AI working group, did a webinar with a deeper dive when the rule first came out that we will include a link to in the show notes. So that was deliverable number 2. For deliverable number 3, we turn to the executive order's requirement for each federal agency to designate a chief artificial intelligence officer within 60 days of the date of the executive order. Lynn, can you provide some insight into why this is so important, who the chief AI officer is at HHS, and what are some next steps on federal regulation of AI in healthcare?
I think this is a critical piece of the executive order to focus on because it takes people to be compliant, not just policies and procedures. People need to know who owns the responsibility. This is very similar to what happened back in the 1970s when each federal agency got an Office of Inspector General. It's also similar to what happens when a healthcare company creates a corporate enterprise-wide compliance program. The first element of an effective corporate compliance program is the identification of a chief compliance officer who will own it. This is clearly a better way of handling how our federal government is managing its own enterprise risk management of its own use of AI tools than to have some new federal agency, which had been suggested by some senators in a Senate Judiciary hearing about a year ago. The private sector might learn from what the federal agencies already are doing in terms of enterprise risk management. So the reorganization at HHS in particular elevated Mickey Tripathi to the position of Assistant Secretary for Technology Policy. He is also serving as the acting Chief AI Officer, in addition to his prior role as the National Coordinator for Health IT. He is tasked with coordinating the agency's internal use of AI, as well as leading efforts to regulate the healthcare industry's use of trustworthy AI. As directed by the executive order of last year, Assistant Secretary Tripathi recently announced a strategic plan to stand up assurance labs that would supplement FDA regulation and provide a place where AI tools could be checked before use. This plan also is part of the transparency provisions of the HTI-1 rule we discussed before. This new AI safety plan with assurance labs is set to be released in January 2025. We will have the beginning of a new presidential administration at that time, so it'll be interesting to see how that develops. Of course, we will be keeping a close eye on that progress.
Thank you, Lynn and Eleanor, for that overview of these 3 key deliverables of the White House Executive Order on AI that have moved the needle forward on transparency and governance around the trustworthy use of AI in healthcare over the past year. Eleanor, I want to turn to you now and ask about other efforts to regulate AI at the state level, which I know could be its own podcast, but I think it is important to understand how state action could impact regulation at the federal level. As healthcare companies consider integrating AI into their day-to-day, how should they be keeping up with all of these state attempts to regulate in this space?
So the states are really interesting on issues involving AI in healthcare. Justice Brandeis famously called the states the laboratories of democracy, and that's exactly what we have here with AI. States are experimenting with novel means of regulating AI in healthcare, and that will likely inform federal regulators and Congress going forward. So basically, the only way to ensure compliance with these novel laws is to monitor what the states are doing, and that is a particular passion of mine. I'll give you a few themes we've seen. In New York and Oklahoma, we've seen bills that require insurers and HMOs to provide notice that they're using AI in utilization review. So Oklahoma's bill went even further than New York's and required an affirmative certification from the insurer or HMO that the AI isn't discriminatory. Both of these bills failed sine die, which means that the bills did not pass before the end of the legislative session. But we are keeping an eye out to see what happens this session. These bills are really interesting, especially in light of the class action and shareholder suits we've seen against insurers. Without naming names, these suits generally allege that claims were denied by an AI algorithm without any human supervision. So calling back to the OCR rule, it's not unreasonable to believe that it will be expanded to apply to revenue cycle management and the financial side of healthcare. Now is a great time to develop a compliance program and robust corporate governance focusing on AI. Another really interesting state AI law is Utah's AI Act, which went into effect on May 1 of this year. The act provides different standards for AI in regular commercial use and for use in healthcare. For commercial use, the act imposes an obligation to disclose the use of AI only if prompted by the consumer. Regulated professionals, on the other hand, like healthcare providers, must, quote, prominently disclose the use of generative AI at the beginning of a conversation or at the top of an email. Exactly how much to disclose is unclear in the act. Does a provider have to disclose an AI scribe or a chatbot scheduler? We're keeping an eye out for enforcement that will clarify this. Note that in Utah, the failure to disclose can lead to civil penalties of up to $5,000 per violation. Now, if that applies to each email, the dollars can add up pretty quickly. I also want to mention the Texas Attorney General's first of its kind settlement with a healthcare generative AI company. So according to the Texas AG, 4 hospitals were sending patient data to the AI company, which summarized patient conditions and treatment. The AI product was advertised as highly accurate, which the AG apparently disagreed with. The settlement did not impose any fines or monetary penalties, but it does require marketing and customer disclosures. Finally, it is worth mentioning that the Electronic Privacy Information Center, also known as EPIC, and the National Conference of State Legislatures are great sources for state AI laws. We at EBG also continue to monitor and provide synthesis of these laws, describe what enforcement looks like, and explain how these laws apply to the healthcare industry.
Thank you, Eleanor. We have seen state laws repurposed and expanded at the federal level, especially in healthcare, and it will be interesting to see the future impact of these state actions and how they impact federal regulators. Lynn, you have been practicing health law a long time. What are lessons learned from previous technological advances in healthcare? And can you speak more about the enterprise risk and corporate governance piece of how to be prepared even before any specific legislation passes into law or any further regulation is finalized?
I remember when there was no corporate compliance programs in healthcare companies, and the Office of Inspector General at HHS was encouraging healthcare organizations to adopt these voluntary corporate compliance programs and not wait for a corporate integrity agreement after a settlement. New positions were created called Chief Compliance Officer. This initiative emanated from our U.S. sentencing guidelines, attempting to encourage corporations to please police themselves and manage their enterprise risks. Existing laws already apply to the use of these AI tools, which is why we are recommending to clients that they consider creating a dedicated compliance program for their creation and use of AI tools that follows the same 7 elements of an effective compliance program that OIG at HHS has previously created. You may want to have a separate hotline, a separate compliance committee, identify your 7 elements, and have a platform to manage these initiatives to be able to demonstrate at a later time that you were a good corporate citizen. And why would you want that to be special for AI? Because when AI tools are wrong, they are wrong systemically and need to be managed differently than human error.
I think that is a great point to end on. Thank you, Lynn and Eleanor, for taking the time to participate in today's discussion on the impact of the executive order on the safe, secure, and trustworthy development and use of artificial intelligence on the healthcare industry. If any listeners would like a broader view of AI in healthcare, including a conversation about bias and corporate governance, please check out the webinar Lynn and I recently did with the Alliance for Health Policy entitled Demystifying AI Tools in Healthcare, an Introduction for Federal Policymakers. We will include that link in our show notes as well. Thank you to all of our listeners. I'm your host, Rachel Snyder Good. If you like what you've heard today, please don't forget to like and subscribe. Diagnosing Health Care is available wherever you get your podcasts.
Thank you for listening to Diagnosing Health Care. For show notes on today's episode, additional episodes, and more insights on trending issues in healthcare and life sciences, please visit diagnosinghealthcare.com and be sure to subscribe on your preferred platform. This podcast is presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.